My name is Nicholas Height. I'm a lawyer licensed in Louisiana with over a decade of experience committed to working with adult and child survivors of intimate partner violence, stalking, and sexual assault. This video is only informational in nature, and even though I am a lawyer and I am going to be talking about legal topics, I'm not giving you legal advice, and nothing I say in this video should be considered legal advice. If you have questions about anything I talk about, or questions about your particular legal situation, you should seek out a licensed and experienced attorney who will be able to provide you with legal advice specific to your needs. This video is designed to help you understand how to file a petition asking for a civil order of protection from abuse, sexual assault, or stalking. You've probably heard this kind of order called a restraining order or a protection order. Those are commonly interchangeable names. This is not the same thing as a no-contact order issued by a university or a criminal stay-away order issued by a criminal court, or even a civil injunction which is also issued by a civil court. There is a separate video that goes into more detail about each of those different documents. The type of court order I'll be talking about is the kind of order that is issued when someone files using the petition forms created by the Louisiana Supreme Court and the Louisiana Protective Order Registry. The language and descriptions I use are going to relate directly to those forms that are publicly available for anyone to download and complete with or without the assistance of a lawyer. The first step in preparing the petition is identifying what category of harm is alleged to have occurred. The law classifies the harm in part based on what the physical act was, and in part on the relationship between the alleged perpetrator and alleged victim. If the victim and perpetrator are current or former intimate partners, dating partners, family members, or household members, then physical or non-physical violence, sexual assault, and/or stalking between them can be considered domestic abuse or dating violence. LPOR Form B is designed for these circumstances. If the victim and perpetrator are strangers or acquaintances, then sexual assault or stalking between them is eligible for a civil order of protection from abuse. LPOR Form D is designed for these circumstances. If the victim and perpetrator are strangers or acquaintances, then physical or non-physical violence that is not sexual in nature between them is a crime but is not eligible for protection under a civil order of protection from abuse. If someone has filed a petition for protection from abuse against you, and you also need to request an order of protection against them, then you will need to file a petition in reconvention. The format of those forms are the same as the documents I'll be discussing. The second step in preparing the petition is determining who needs protection and who do they need protection from. Petitions can be filed by competent adults on behalf of themselves or their children, or incompetent adults, or both. A competent adult can't file a petition on behalf of another competent adult. They have to file for themselves. The petition should be filed against the person alleged to perpetrate the harm or their competent adult representative. If the harm was perpetrated by more than one person, separate petitions should be filed against each of them, even if they're working in collaboration or all participated in the same incident. If you don't know the defendant's name or current location, you may want to speak with an attorney about what to do, as you may not be able to proceed without that information available. Once you've determined which form is appropriate for your circumstances and you've identified the petitioner, the person requesting protection, and the defendant, the person they need protection from, you need to identify the proper place to file the paperwork. It can be filed where the petitioner lives, where the defendant lives, where the harm occurred, or where the petitioner and defendant last resided together. An important note is that the petitioner has the right to request that their address be kept confidential. If you are the petitioner and you want your address kept confidential, be sure to fill out LPOR Form F, the confidential address form, and file it with your petition, and don't include any portion of your address in the petition paperwork. After you've provided the identifying information for the petitioner and defendant, determined which court to file in, allegations of harm have to be provided. Regardless of which kind of petition is filed, the petitioner is obligated to describe what kind of harm occurred with a reasonable degree of specificity. The LPOR forms provide several multiple-choice options for the type of harm that may have occurred. Be sure to read the options carefully and mark every type of harm that you allege has occurred, no matter how recent or historical the incident may have been. There is no expiration date for harm that can be considered by the court in these proceedings, but the threat of harm should be considered imminent or ongoing. After the multiple choice options, the petitioner needs to provide a written narrative of the most recent harm, as well as a description of any historical harm that has occurred. This description doesn't have to be a totally comprehensive account of every last detail, but it should provide enough specific information so that the defendant is put on notice about the who, what, where, and when of the allegations being made against them. In addition to detailing what has happened, you'll need to detail what you want to have happen next, or what kind of relief you are seeking from the court. The LPOR forms provide a number of options for the type of relief that you can request. It can include limitations on contact, access to property or possessions, the temporary use of a home, child custody and financial support, and/or reimbursement of medical expenses arising directly from the harm. You can also request who is cast with court costs and attorney's fees, and if you think someone should participate in counseling or mental health services. Be sure to mark off any and all relief that you are requesting from the court. If it isn't marked, it may not be considered a valid request, and you may forfeit your right to that relief. Once you've provided all of the details about the petitioner, the defendant, which court to use, the allegations of harm, and the kinds of relief being sought, the petitioner has to sign the petition in front of a witness, thereby swearing that all of the information provided is true and accurate to the best of their knowledge, and understand that knowingly providing false information could result in penalty from the court. There's no longer any need to have the petition notarized, and the witness doesn't need to know anything about the content of the petition. They are simply witnessing the petitioner's signature as a knowing and voluntary affirmation of the contents of the petition. Each petition also needs to be accompanied by a temporary restraining order. You may have heard this referred to as a TRO. This is LPOR Form Number 1. This temporary order, or TRO, is issued immediately without notice or hearing by the defendant when the petition is filed, and may provide temporary protections until the parties have a chance to be heard by the judge. Each judge has the choice to grant or deny any portion of the relief requested in the TRO. It's important to make sure that the relief requested in the petition matches the relief requested in the TRO. The TRO will also include the court order for the petitioner and defendant to come back to court for the formal hearing on the allegations, which is when the judge will decide whether or not to issue a longer-term order of protection. When the petition and accompanying TRO are filled out completely, they need to be filed with the clerk of court. The clerk of court for each parish can operate in a slightly different way, but generally they all require the petitioner to bring the original completed and signed LPOR petition and TRO to be given a case number and assigned to a judge. There is no upfront cost whatsoever to the petitioner associated with filing a petition for protection from abuse. The judge ultimately decides who bears the cost of the filing after the matter comes for a hearing. Once the petition has been assigned a case number and judge, the petition can be taken to the assigned judge for signature. Because these petitions are considered emergency in nature, it's common for the assigned judge to direct the petitioner to the so-called duty judge or on-call judge to get the initial order signed. The assigned judge may still have to give the hearing date from their calendar, but once that is done, they may direct the petitioner to the duty judge to get a ruling on the rest of the relief requested in the TRO. Usually the judge does not talk directly with the petitioner before signing the order. Do not expect to have a chance to make your case to the judge while they're reviewing the petition. That type of one-sided communication about the case is prohibited. At this point in the process, the petition paperwork must speak for itself. The law of Louisiana requires that a petition for protection from abuse be scheduled for hearing within 21 days of the order being signed, unless the judge has good cause to extend it further out. Once the TRO has been signed, it's important to take all of the original documents back to the clerk of court to get certified copies and to have the paperwork served on the defendant. Again, the operations of each clerk of court may be slightly different, but generally speaking, the clerk should make copies of the petition and TRO, which are certified with a raised seal and original signature by a deputy clerk. At least one of those certified copies should be provided to the sheriff's office, who's responsible for making sure the paperwork is served on the defendant before the court date. At least one additional copy can be kept by the petitioner for their reference or to show to law enforcement if needed. If the TRO has instructed the sheriff to assist in eviction of the defendant and/or supervising the defendant's retrieval of personal belongings, or in transferring the physical custody of personal property or physical custody of a child, be sure to notify the sheriff's office so that they can coordinate the needed officers to execute and enforce those orders as quickly as possible. If you file in Orleans Parish, you'll typically have a chance to discuss these issues with the sheriff's office when you bring them the paperwork to have it delivered to the defendant. If the defendant is in a different parish, you'll need to notify your local sheriff about the need for service first, and then coordinate with the sheriff for that different parish to get the defendant served. If the defendant is located outside of the state of Louisiana, that will require something called long-arm service. This typically requires coordinating with the local sheriff for the defendant's location to ensure the paperwork is properly served as quickly as possible. The law requires long-arm service be completed at least 30 days before the hearing date. Since this is longer than the 21 days required to set a TRO hearing, petitioners may want to notify the judge of the intention to use long-arm service to see if a later court date is possible. The petitioner and defendant are obligated to appear in court on the date and time indicated in the TRO. At that point, a few different things might happen. The petitioner might appear for the hearing and find out that the defendant has not been served with a copy of the paperwork, and therefore hasn't been officially notified of the allegations and the hearing. Without service on the defendant, the case can't move forward. If there is no service, the petitioner may choose to have a new court date issued and attempt to serve the defendant again, in which case a new TRO will need to be completed and provided to the sheriff again for service on the defendant, along with the original petition. Or, if there is no service, the petitioner may choose to have the petition voluntarily dismissed without prejudice, which means the paperwork is dismissed and the case is ended, but because there was never any hearing on the allegations, those exact same allegations can be filed again at a later date. Or, the petitioner may choose to have the petition dismissed with prejudice, which means the paperwork is dismissed and the petitioner is also forfeiting the right to ever argue the allegations in the paperwork at any point in the future for a restraining order. If the petitioner fails to appear on behalf of their petition with or without service on the defendant, the paperwork is automatically dismissed without prejudice. If there's successful service and the petitioner appears in court, but the defendant fails to appear for the hearing can move forward in the defendant's absence. The petitioner is still required to present a valid case to be granted an order of protection, but the hearing can happen and a final order can be issued without the defendant being present. If there is successful service and each party comes to court, but either party requires additional time for whatever reason, they may request the case be continued and reset to a later date. The law requires that the hearing be rescheduled within 15 days unless the judge decides there are exceptional circumstances or the parties agree to a later date. Alternatively, the petitioner and defendant might both appear for the hearing, and the petitioner may decide they no longer wish to pursue the restraining order. At this point, the petitioner may again choose to voluntarily dismiss the petition with or without prejudice. If a petition is voluntarily dismissed by the petitioner, there is no cost cast on the petitioner or defendant. Court costs are only cast on the petitioner by consent of the parties or if the judge determines that the petition is frivolous, meaning without any actual merit or basis in the law or solely designed to harass the other person. It is always possible for the parties to reach an agreement among themselves without having a hearing with the judge. The agreement can include almost any variation of the relief requested in the petition. It is also possible for the parties to agree to an entirely different form of relief altogether. For example, the parties can agree to a civil injunction in lieu of a restraining order, which can provide many of the same protections against harassment and abuse, but which generally has no criminal enforcement mechanism. violating an order of protection is automatically considered a criminal offense and should result in the immediate arrest of the violating party. Alternatively, violation of a civil injunction is a civil offense and can result in contempt of court. For violation of a civil injunction, an arrest would only be made if the act violating the injunction is also criminal in nature, regardless of the injunction. If service has been made on all parties, a petition is not voluntarily dismissed, and there is no alternative settlement agreement, then there will be a hearing on the merits of the petition. During the hearing, the parties will have an opportunity to provide testimony from themselves and any other witnesses. They will have an opportunity to question any witnesses called on their behalf or against them, and they will have an opportunity to introduce any documentary evidence they may have supporting their claims. Even if someone does not have a lawyer, they are generally expected to try to present their case in the same way a lawyer would and try to follow the procedural rules and limitations of a courtroom. Most judges tend to be mindful of the vast difference in knowledge and skill that can exist between lawyers and laypersons. There is a separate video that outlines more of the specifics about how a hearing works, but there are also legal aid organizations available for folks who are seeking to file a petition for protection from abuse, stalking, or sexual assault. It can often be worthwhile to seek out that assistance if it's available to you. At the end of the hearing, the judge will issue a ruling on the petition and will either grant or deny each of the requested forms of relief. Orders of protection can generally be put in place for up to 18 months. There are some portions of the order that can be made permanent, but many portions of the order cannot extend beyond 18 months at a time. If your relief is granted, the order becomes immediately enforceable. A copy of the order is sent to the Louisiana Protective Order Registry, which operates as a statewide database accessible to law enforcement and courts. If any portion of the final judgment requires enforcement by the sheriff, they will need to be notified by one of the parties to arrange for the enforcement to take place. If your relief is denied, you may seek an appeal of the judgment and should speak with a lawyer regarding those options. Generally, an appeal must be lodged within 30 days of the judgment. Even if you seek an appeal, the judgment of the court remains binding unless and until the Court of Appeals intervenes. Even though a petition is denied, the petitioner cannot be cast with court costs unless the petition is ruled frivolous by the judge. If cross petitions are filed, then it is possible for both parties to be subject to a restraining order at the same time. However, it is not required for both or either petitions to be granted. Additionally, if cross petitions are filed, it is possible to enter into mutual civil injunctions as an alternative settlement, but neither party is required to make that agreement unless they want to. I hope this video has been helpful to you. I understand that it may not have answered all of your questions, and I would encourage you to consider contacting a licensed and experienced attorney to address any specific legal questions you may have about this process or your circumstances in particular. If you're working with a university or community advocate or organization, those folks may be able to help connect you with additional resources, including legal support.